was pretty much the same. I thought I had more safety and security than living on the streets, but after my place got broken into, it was like being there all over again. Although for different reasons, living on the streets.
That the filing of the discontinuance by the city had been an abuse of the court's process. All right. So we're back on track. We're looking at our trial date. Also, in the interim here, you should know there's another thing that goes on, and that's the thing, because there's a constitutional issue being argued, we have to inform the Attorney General of BC and the Attorney General of Canada that the court's going to be asked to rule on a constitutional question, and those bodies then, by right, under legislation here in this province, can become interveners, can take part in the action. Canada had notified us that they would not be taking part, but asked to be kept informed if it went up to a higher level of court, and the Attorney General of BC did intervene. So the Attorney General became part of the action at this time. So in early September, September 10th, which was the day we had set to argue the matter, we showed up in court, and the Attorney General of BC was there, and the City of Victoria and the AG sought an adjournment. They had a number of arguments, one being that the AG had just become involved, needed time to look at the evidence, this kind of thing. But another very important point that the city advanced was that the Mayor's task force was due out very shortly, and that this would be very important evidence for the court, and we should not have the hearing should not proceed before the task force report was available. So the adjournment was granted, and the task force report did come out on October 19, 2007, and as we'll tell you, it did indeed turn out to be very important evidence before the court. However, it was evidence to our benefit largely, so we were quite pleased with it. So, again at this time, now the AG was in play, the Attorney General brought an application to basically have the action dismissed, or have our statement of defense dismissed, on pretty much procedural grounds. They said our pleadings weren't done right, we should have done a counterclaim, we really couldn't ask for this, we should have been asking for that. They had all these arguments. So we had to go through another application, and that was another, was that 1 or 2 days, Kevin?
I don't remember. We went to court and we were supposed to do it in November, and then we went back in January, and then we were back in whenever it was. February.
Well, we went to court ready to argue this originally, I think on October 30th. So we showed up ready to argue this application and say no, it shouldn't be thrown out because of. And the Attorney General then took the position that the city bylaws didn't prohibit sleeping. People could sleep. And we turned around and said, City, is that true? Can people sleep? Well, yes, they could sleep, but they could only sleep with soft coverings, and they couldn't have tarps, and so there was all this. And we've been asking for this clarification, you must remember, for a long time. We've been writing and asking. So we then had the information that said, no, well, we think they can sleep. And then we adjourned, and we again didn't go ahead before the court because the city's lawyers really had to get instructions on what people couldn't do. They really couldn't tell us because we said, well, can they cover this house with a tarp? Well, we don't know. No, we don't think so. So we adjourned again, and again tried to pin down, just what the bylaws were and what the violations were. So, keeping in mind that when we go back to October 2005, the issue was you can't sleep in a public place. Now the city is saying, oh yes you can, we're letting you sleep. But it turns out what's happening here is that there was a police operational policy that was put into place. And it appears this was in the summer of 2007. In the summer of 2007, the city also amended its parks regulation bylaw. And in amending it, they dropped the word loitering. So it was no longer an offense to loiter or erect a temporary abode. It was only an offense to erect a temporary boat. So the AG's interpretation of this was that it was the loitering provision that prohibited sleeping, and so now that loitering was gone, people could sleep. But they couldn't put up any shelter. So we thought, well, that seems a little bit kind of hollow, like we live on the West Coast and it rains, it snows, it gets very cold, and you can't protect yourself from the elements. So the case moved on, but it moved on with a slightly different twist, because the question now was, could the city prevent people, homeless people who had nowhere else to go, where there was no shelter beds available, could they prevent them from erecting shelter? And that was kind of the question that went before the court. Now, again, I'd just like to backtrack and throw a little bit of evidence into this, because when we were in court in 2005, in October 2005, on the original injunction, the evidence before the court at that time was basically from the Kool-Aid 2005 homeless count, which counted about 700 homeless people in this city. And the evidence at that time was that there were about 170 or 171 shelter beds available. So there was a big gap. We got to 2007, and we were before a number of judges, and the Kool-Aid 2007 Homeless Needs Survey was completed and published, and it showed, or it indicated that there were 1,240-some homeless or unstably housed people in the city. The number of shelter beds had not increased. It had remained at 171. When we got to court in June of this year with the Mayor's Task Force, which had been released in October of 2007, the Mayor's Task Force had noted, it said there are 1,500 homeless people in Victoria. And the task force says, and I don't know exactly where again, the task force says 141 shelter beds, permanent shelter beds, increasing to a maximum of 326 when the extreme weather protocol kicks in. Now, you know, that document became really a key piece of evidence before the court, because it was, you know, the city's own evidence that these are the numbers. Can't really argue with them. So the number of homeless people had risen dramatically in the time that we were involved in this case, in just 3 years. And the shelter had not increased with that. So that's the kind of evidence we went to court with. We went to court armed with evidence, just to give you an overview of what was before the court. We had evidence from the campers in Cridge Park, the original campers, 20-some affidavits, I believe, some very compelling stories. People told their stories very openly. There was a wide variety of people, of circumstances, age, how they got there, what it was about. There was a lot of evidence from them that when they were camped together in groups, they felt safer, their belongings were secure, they could leave them with friends, etc. So we had that evidence from the 2005 tent city campers. We had further updated evidence from other homeless people as we went through the case. We had solicited and took to the court expert evidence. Probably most notably, a doctor in Toronto, Dr. Stephen Wang, who is a epidemiologist who specializes in caring for homeless people at St. Michael's Hospital.